Remarks by members. Senior Senator from the 8th.
Thank you, Mr. President. I know that it's late, and I'll be brief on these remarks because it's late, and I know Judiciary's got a large amount of work ahead of them. But I know Judiciary is considering some pieces of legislation, and I'm not on Judiciary, so I don't get to ask a lot of those questions. And I kind of wanted to stand up and put up some of my concerns that I have towards the bill, and hope that some of the Judiciary members will listen and will consider these concerns as they take on some pieces of legislation. First, I wanted to talk about some of the information that's going around about a bill that I'm just not sure what's true and what's not, because there's so much out there. And I know the Senator from the 8th talks so well that there's so much out there, and I don't know all the way what's true, but I've got this piece of information about House Bill 4012 that says that in no way this bill lets a restaurant owner deny services to any type of person. But then I have the reasons for the bill, and every single reason is about that this bill is needed is so that these individuals can deny service to a community of people. So I don't know which one's true, Mr. President. I don't know what the bill is going to be doing, and I hope that can be hashed out in Judiciary Committee. There's talk about whether this bill is a sword or a shield, and I know that whenever we create a new cause of action, or when there are causes of action, it's hard for it not to be both. If you look at nuisance suits, for example, all the natural gas companies will tell you that that is a sword. However, if you talk to the landowner, they'll say that is their shield. And in bringing up nuisance suits, I know that out-of-state attorneys came in here. Well, on this bill, I've not seen a single in-state attorney lobby for this bill. The only attorneys I've lobbied for it are out-of-state attorneys and out-of-state interests. To speak of the new cause of action, Mr. President, since House Bill 4012 and other states have taken it up, over 15,000 cases have been filed under RFRA. Over 15,000 cases have been filed, so those are new causes of action. And I know that it's been filed in some cities across the nation where they've used it to take back city ordinances, saying that those city ordinances are a violation of people's religious freedoms. So those cities are now facing lawsuits all across the nation, Mr. President, and that's a concern I have. You know, we see that 781 of the world's largest corporations have non-discrimination laws, and I'm concerned that this bill might discriminate, and in saying that, I have to say that there are multiple states that do have this on the books, and they have in the books, in the language, saying that in no way will this bill discriminate. And I hope that finds its way into the bill, because if we're just establishing a test to protect people, I hope that test isn't used to discriminate in the name of God. I really, that's what I'm fearful of. I don't want to have to vote for a bill that I have to look at God and say, I voted for a bill to allow people to discriminate in your name. And I don't know if it does this. I know we don't have a final bill. I know Judiciary Committee is working on it, and I think so highly of this process. I know there are multiple faiths for this bill. I know there are multiple groups of faiths that are against it. So it's a divisive bill amongst religion, and that's unfortunate to see, but that's part of this process. But I want to talk about one final thing, Mr. President, and it's about the Supreme Court of the United States. It's about the Hobby Lobby ruling, which is something that's been at the center of this bill. And it's about some of the writings by the Supreme Court justices. And as part of the 4-point test, one of it is you have to prove you have sincerely held religious beliefs. Well, in the Hobby Lobby decision, the Supreme Court wrote that the court shall not be an arbiter between you and your God. The court shall not be an arbiter, a judge between you and your God. Therefore, if you say you have a sincerely held religious belief, that must be accepted as true. So since the court is saying that they are not going to get in the way, if you say this is my religious belief, they're not going to judge if that's sincerely held or not, that will automatically pass muster. And you know, that opens up the door for so much and makes it so broad. Now, I know the bill's not finished, and I know that the bill can get to a point that everyone can be comfortable with it, Mr. President, and I hope it does. But I have a lot of these concerns. Concerns that in the state of West Virginia, there have been cases filed where individuals had filed not to vaccinate their children to go to school, and those cases have won. And underneath this, they now have another defense to take away the vaccination laws. Those cases have won here. We've had kids go through the public school system without having to be vaccinated. So to say that you can't show a legitimate government interest, that would be taken out, well, we've not been able to do that in the past. So this gives another pathway for that, I fear, and I don't know. I don't know how it's going to be by the end of the committee. I just hope the committee can bring those concerns up, ask, are municipalities going to be able to be sued underneath this provision for having ordinances? Are people going to be able to discriminate based on a new provision? And then, Mr. President, finally, are the vaccine laws that we're very proud of in West Virginia at risk? Those are the things I'm concerned about. I don't want to speak either way on the bill. I just hope these types of questions are asked and concerned in committee. Thank you, Mr. President.